Hey guys, this is John Watts. Thanks for watching this video. We're going to go through another case decision here. This is out of Georgia earlier this year involving the FDCPA, Fair Debt Collection Practices Act, and specifically involving the definition of consumer debt. In other words, how do we know that a debt is actually covered under the FDCPA? And that's what this case will discuss. And let me just point out kind of procedurally how this opinion came about. This is from Judge Mark Treadwell. So both sides move for summary judgment. Summary judgment is where you say to the court, there's no reason to have a trial because no reasonable juror could find against me. And let's give the other side every benefit of the doubt. And I still win because no reasonable juror could rule against me. Well, cross motions for summary judgment, that's where both sides are filing. So kind of think of them as crossing in the mail. So the defendant's saying, Judge, there's no reason to have a trial because my decision, my point of view is the only one that can win. And the plaintiff is saying the same thing. Now you'll notice this says partial summary judgment. That's where you're not asking that the entire case go away, but just parts of it, something less than the whole, will not be submitted to the jury. In other words, the judge will decide. So let me give you a simple example. In personal injury, which we've been doing for 24 years now, we might be suing a trucking company and we say, Judge, you need to find liability. In other words, this trucking company is at fault. It was negligent or reckless. But the amount of damages, that needs to be left up to the jury. So if the judge agrees, she would grant summary judgment on liability, and we would start off the trial with the judge saying to the jury, look, ladies and gentlemen of the jury, I've already found that the trucking company is at fault. I've already found that they violated the law. Your sole role is to determine the amount of damages. So that's what a partial summary judgment is. You'll also notice there's something called the Georgia Fair Business Practices Act, GFBPA. It's broader than the FDCPA, but just think of it as it's a state version of the FDCPA. So Florida has a state version of the FDCPA. Georgia has it. And you can get some enhanced damages under this law. Whenever we've been brought into Georgia lawsuits involving the FDCPA, this has always been included. And it's a wonderful law. In Alabama, we don't have this. And some states don't have a state version, but Georgia has a very good one. So that's why the lawyer that brought this case did that. And so the basic background, and let me just describe it rather than going through it all here, but you can read it while I'm talking, is the plaintiff had a former employer who said, look, I've got this old electronic testing equipment. If you want it, go get it. So basically like, kind of think of it this way. We're setting it out to be picked up by the garbage truck, but you can take whatever you want. And so then he puts that equipment in his sister's garage and he builds mini race cars, he builds fans, and then whatever he doesn't use, he sells that on eBay. And it'll point out it's his personal eBay account. And then the money from those sales go to his personal bank account. So then he contacts a business and they say, hey, look, we'll buy the majority of your equipment. And again, the money goes to plaintiff's personal bank account, or PayPal account, which then goes in a personal bank account. And the buyer says, look, we'll pay the cost of shipping. And so they use FedEx Freight. And there's a bill of lading. He takes it to the dock. The FedEx ships it. And then here's where it gets interesting. The FedEx employee says, actually, the buyer's responsible for the payment of the shipping. So you don't have to pay FedEx any money. So great. But then later, he gets an invoice for $1,000 saying, actually, you do owe this money. And the plaintiff says, well, I never got it. And then they send him another invoice. And he does get that one. The plaintiff calls and says, what's going on? And they say, well, there's some defect, and so we decide you're responsible for the $1,000 charges. So plaintiff tries to get with the buyer, can't get them, and he continues to get invoices. So, right now there's no FDCPA because he's just dealing with, quote, the original creditor, FedEx. But now FedEx places the account with the defendant who's a debt collector. And so November 8th, they send him a letter that complies with the law. And then on December 5th, they leave him a voicemail. And this would not comply with the FDCPA because it does not say, hey, this is an attempt to collect a debt and we are a debt collector. And so on the 8th of December, so that's about a month after the first letter, they send a second letter. And then December 11, the plaintiff sends a dispute letter demanding verification. This is the plaintiff's right under 1692G. We have a video on that. I think, maybe last week we did a case decision on debt validation. And the defendant says, look, I never got it. Well, here's the significance of that. If you're dealing with a company that's willing to break the law, then you have to assume they're willing to lie about getting your dispute letter, your validation letter. They'll just throw it away. So you have to send it by, ironically, FedEx or UPS, but normally it's just sent by certified mail, so it's going to cost you like $7 or $8. And that way you can prove that they received it. And then after he sends that letter, the defendant leaves another voicemail. And then there's more demand letters. And then there's more voicemails. And so then he ultimately sues them and says, look, you violated both the federal law and the Georgia law in two ways. You didn't identify yourself as a debt collector in a couple of the voicemails. And you did not cease collection activities after you got my letter requesting verification disputing the debt. So keep in mind, as we've talked about before, if you send a proper validation verification letter, the debt collector has only three options. Number one is do nothing. So they don't verify the debt and they don't collect the debt. Or number two, they can verify the debt, and assuming they do that properly, then they can continue to collect the debt. And number three is to get rid of it. Send it back to the original creditor. Here that would be FedEx. Or maybe if they own the debt, they could sell it to another debt collector. But those are their only three options. And the plaintiff's saying you didn't do one of those. Instead, you continue to collect the debt. So what is summary judgment? I've already described it in general, but here's some quotes about what it is. It's when there's no genuine issue as to any material fact. So material fact just means an important fact, a fact that makes a difference. And second, the party that's moving for summary judgment is entitled to judgment as a matter of law. And the court points out it's not just any old factual dispute that prevents summary judgment. It has to be a material fact that's in dispute. And then we have what's called the moving party. So that's a party that is moving or requesting the court to enter summary judgment. They have this initial responsibility of showing the court that there's an absence of a genuine issue of material fact and that they are entitled to judgment as a matter of law. In other words, they're correct on the law. And if they do that, then the burden shifts to the non-moving party, the other party, to not just point to their complaint or their answer and say, see, there's a dispute, but actually show evidence. So this could be interrogatory answers. This could be requests for admissions. This could be deposition testimony. It could be affidavits, sworn statements. And the court also points out, let me go down here to a footnote, when a court looks at factual issues, they have to be viewed in the light most favorable to the non-moving party. So if you look at a fact and you say, well, I could interpret this in favor of the defendant who's moving for summary judgment, Or I could interpret it in favor of the plaintiff who is on the receiving end of that summary judgment. You've got to rule in favor of the plaintiff and say, if there's any inference, if there's any sort of legitimate way to look at this in two different manners, then you've got to go in favor of the non-moving party. So to get summary judgment is not the easiest thing to do. And that makes sense because what you're doing is you're taking that case away from a jury and saying, we're not going to let you decide it because no reasonable juror could rule in any other way. So if that's your standard, then it certainly has to be hard to do, and you have to give the benefit of the doubt to the non-moving party. So let's get into the actual law. The FDCPA, and this will be familiar if you've seen our other videos. Section 1692 is the purpose of the law. It's to prevent the use of abusive, deceptive, unfair debt collection practices. And when we are talking about legal things or a cause of action, in other words, you're suing somebody. If it's a car wreck, you're suing them under negligence or recklessness. If it's fraud, you're suing them under fraud. Well, we always have elements. These are requirements to prove your case. So some judges will break the FDCPA down into 4 elements and some will do it 3. This particular judge in Georgia does it in 3 elements. It's all the same thing, it just kind of depends on how you want to word it. But this judge says, number 1, the plaintiff has been the object of collection activity arising from a consumer debt. Number 2, the defendant is a debt collector. And you'll notice both of these talk about as defined by the FDCPA. That's 1692A. Is a whole list of definitions. And then number 3, the defendant has done something that violates the FDCPA. And because this is a consumer protection statute, it's to be construed liberally in favor of a consumer. So in other words, if it's kind of like, well, I could go either way on this, then you should lean toward the consumer. And here's what the defendant argues. He doesn't argue that, we're not a debt collector, the plaintiff's not a consumer. Instead, the defendant simply says, this is not a debt, as defined by the FDCPA. And the plaintiff says, no, I meet all the elements. And you'll notice the plaintiff actually lists 4 elements. Again, you can break this down into 4 or 3. The difference is really number 1 here, consumer. Number 2, debt collector. Number 3, the debt's covered. Well, the judge combined consumer and debt. Okay, but it's just sort of semantics. And the defendant does not dispute it's a debt collector. The plaintiff's a consumer. And instead, everybody's arguing over, is this a consumer debt or a debt that's covered by the FDCPA? So how do we figure it out? Well, we read it. That's why, we had the time to do the video on the definitions, and I've been guilty of skipping that when I've been in lawsuits, of saying, oh, well, I know what the definitions are, but you really have to go back and look at them in every case and say, okay, am I a consumer? Is this a covered debt? In other words, a debt that's listed under the FDCPA. Is this really a debt collector? And we had a video, I think earlier this week, on, is a debt buyer actually considered a debt collector? And so that's why we keep coming back to the definition. So here's the definition. Any obligation or alleged obligation, so you don't have to actually owe it, you just have to have a debt collector say, you owe this debt, and then it's covered. If it is the subject of the transaction is primarily, not 100%, but primarily for personal, family, or household purposes. So here's another way to say it. If it's related to business or commercial debts, it's excluded. And so again, the debt must involve consumer transaction. So you see the court will always go back to the statute and go back to other cases to get guidance in making a decision. And the court notes that you need to look at the transaction as a whole, and you consider the purpose for which the credit, or you could just substitute the word debt, was extended. And so the court's going to look at the 11th Circuit. The 11th Circuit is the appellate court that governs Alabama, Georgia, and Florida. And so that is above the district courts or the trial courts in federal court. And so we have this case, Oppenheim versus IC System, Inc. And the basic gist is the plaintiff, the consumer, sells a laptop to a buyer, and by Craigslist, they're going to use PayPal. And the agreement is if PayPal reverses the transaction because the payment was invalidated by the sender's bank, then the consumer, Oppenheim, bears the risk of that and has to pay PayPal. So sure enough, the payment was fraudulent, and the consumer says, well, I'm not paying you, PayPal. And the reasons don't really matter. So PayPal hired the debt collector, and then they violated the law. So the debt collector in that Oppenheim case moves for summary judgment, saying we don't need to have a jury trial on this, but the district court denied it. So what happened at trial? Well, the plaintiff got a verdict. That's great. Jury found in favor of the plaintiff, the consumer. And so the debt collector appeals and says, we never should have had a trial. The district court never should have denied summary judgment. But the 11th Circuit affirmed or upheld the denial. So now the cross case that we're looking at here is going to explain why that happened. So the 11th Circuit said, let me just get this highlighted here, said the debt did not violate the consumer purpose requirement because it was a sale of a personal computer, and the funds of the sale were transferred to personal bank account. This guy, the plaintiff, did not run a business, and he registered his PayPal as a personal account, which said this will be used for non-business purposes and primarily for personal, family, or household purposes. You can see that's kind of a standard definition in the legal world. So the plaintiff, back in our case here in Georgia, says, well, look, I'm just like Oppenheim. This is why we look at cases to say, well, can we fit that so that we can say, Judge, you should reach the same outcome. And he says it was for personal purposes because he used these equipment to build fans and little race cars as a hobby, and then he sold what he couldn't use. He did not have a business account with eBay. In other words, it's a personal account. And the money goes into his personal bank account. And he's not in the business of buying and selling electronics equipment. And to FedEx, he did not represent himself as a business. So that's the plaintiff's argument. And so the plaintiff's saying, see, I'm just like that 11th Circuit case, the Oppenheim case. I'm just like that. Well, what does the defendant say? Defendant says, unlike Oppenheim, the debt was for a commercial purpose because you sold commercial grade equipment. You sold it by advertising the items in a widely accessed sales forum, engaged with multiple buyers to complete several sales, and you were actually operating a business, buying and selling this equipment known as a side hustle. So it's kind of a more recent usage, so you can tell this is a pretty modern case here. And the court says, look, I cannot determine whether it was for commercial or consumer. And this is interesting. And we see this come up, but it's kind of a subtle thing. The facts are not in dispute. In other words, what happened? But it's the inference that you draw from those facts. Those are in dispute. So let's look at what's undisputed. Plaintiff had a personal eBay, personal PayPal, went in a personal bank account. But then when you look at this Oppenheim case, there are some things that, how do these play out? So the purpose of the equipment's use and whether it was a side hustle, or disposing equipment while dumpster diving for many racer parts. In other words, did he get these parts to just as a hobby, and then he goes, oh, well, I got some scrap stuff, so I'll just sell it? Or was he going and getting the parts to make the sell? And the court says those are disputed. And again, it gets into a little bit of semantics. Are those disputed facts, or is it just the inference that you draw from the undisputed facts are disputed? Bottom line is the judge says, I'm denying both of these motions for summary judgment because it could go either way. And then the court looks at the Georgia Fair Business Practices Act, and court notes generally an FDCPA constitutes violation of the Georgia Act. The Georgia definition of consumer debt is basically the same as the FDCPA. And then, given the contradictory inferences on the issue of whether plaintiff's obligation is debt covered by the FDCPA, a material factual dispute also exists on whether it's covered under the Georgia law. And so that's denied. And so here's the conclusion. Plaintiff must establish his obligation to pay the defendant as a debt within the meaning or the definition of the FDCPA. There's a genuine issue of fact about that under the FDCPA and the Georgia law, and so it's denied. And then there's some footnotes that give you a little bit more information. So that's the case. And the reason I went through this is because we do have to make sure, and I've been guilty of not doing this on the front end. Unfortunately, it's always turned out, but I really try to discipline myself to say, okay, this may be a great FDCPA case, but I need to make sure this is a consumer debt. So I ask my clients, all right, this repair bill on a car, is that your personal car or is that a company car? This credit card that you have, the debt, not necessarily the card, but the debt that they are collecting, was that for your employer, for your business, or was that for personal, medical, going to the grocery store, going to a movie, going on vacation, paying your electric bill? What was the purpose of it? Because that is very vital. And I hope you enjoyed this video. I'll continue to make these as I have time. And if you have any questions or comments, put those below or get in touch with us, alabamaconsumer.com or 205-879-2447. Thanks for watching this, and you guys have a great day. Bye-bye.